Hi, welcome to Estate Planning for Beginners. Step 1, housekeeping items, non-probate asset designations. Let's get into it. Here's our agenda. First, we'll go over the 3 steps of planning, then what non-probate assets are, why they're important, different forms of non-probate assets, PODs, TODs, and securities, and finally, key takeaways. I'm Tiffany Williams, Juris Doctor, the CEO of Williams Legal. I started this business to join the fight against racial disparities in financial well-being. I chose to approach from the area of estate planning because I believe the racial disparities in access to quality estate planning services and resources are directly related to the racial disparities that are evident in the financial well-being of the Black community as a whole. Statistics show that 27% of Black Americans have estate planning documents prepared, in comparison to 46% of white Americans. My mission is to change those numbers and to reduce the gaps in these disparities. Here's just a bit about my background. It won't be on every video, but since it's the first one, I thought I'd just tell you a little about myself. I've been in the labor market over 25 years. I've worked in every shift, day shift, night shift, overnight shift, split shift. Okay, I've done delivery, I've done sales, I've done taxes. I still do taxes. But largely, my work has been in corporate and in the law after college. I'm a former paralegal. I worked as a paralegal for approximately 15 years, largely in real estate, ranging from Maryland residential foreclosures to Delaware commercial developments. I am a servant of the people. I appreciate the work that I do because of the impact that it has in my community. And I won't go on too much further on me because I don't want the video to be about that. That's it about me for now. I'll give you more in other segments to come, but let's get into the meat of non-probate assets. I've broken down planning into 3 steps to make it digestible. Step 1 being housekeeping items, which is where I've allotted non-probate assets. Non-probate assets are often overlooked. Many clients, even some legal professionals, only focus on wills. They neglect non-probate assets like IRAs, 401ks, life insurance, and joint accounts. And this unintentionally overrides a will's provision when they are not properly addressed. Step 2 is your standard estate plan, which would come with your power of attorney, your medical health directive, and your last will and testament. Step 3, I call a comprehensive planning for larger estates where you will want to consider creating a revocable living trust and the like. But again, we are on step 1. So let's jump right into probate assets versus non-probate assets. To understand non-probate assets, we have to first discuss probate assets. Probate assets are possessions of a deceased person that are subject to the probate process, which is a court-supervised procedure to validate a will, settle the debts, distribute all the remaining assets to the beneficiary and the heirs. That doesn't, being subject to probate is not contingent on having a will. If you have a will, then you die testate. If you do not have a will, then you die intestate and you have an intestate estate, and then that intestate estate is then probated. But non-probate assets bypass the probate process and are directly distributed to the appointed beneficiaries with the financial institutions that manage those accounts. Examples of probate assets are solely owned property, personal possessions, business interest, tenant in common assets, all forms of interest that do not directly transfer at death. Okay, so these are examples of probate assets, all of which would be subject to the probate process of the court. Now, why avoid the court? There's a cost with the court administration, okay? There's also an added delay with the court administration, and the court process is a public process. So whatever assets would be put into that estate would not only be made public record, it would also be made vulnerable to potential creditor claims. So for all those reasons, estate planning, one of the most important aspects of estate planning are finding various ways to avoid probate and to have speedy, fast distributions at the time of death that go to the intended parties of the person who passes away. So revocable trusts, transfer and death deeds, living gifts are all ways to avoid probate. Non-probate assets are a cornerstone of modern estate planning. They're important. They help to protect your privacy from the public process of probate. They help to preserve your assets by avoiding unnecessary court costs and fees. And it also helps you to avoid the delays associated with the court procedures. Because generally, non-probate assets transfer to beneficiaries much quicker than it would if you had to go through a probate process. Non-probate assets generally transfer directly to the beneficiaries at the time of death, subject to some limitations, because you have to also consider whether or not your beneficiary is a minor, because a financial institution will not transfer funds to a minor even at the time of death. But we'll get into that later. Common non-probate assets include payable on death accounts, PODs, transfer on death accounts, TODs, retirement accounts, and life insurance, like 401k and 403bs. And lastly, joint ownership with right of survivorship, which pertains to real property, real estate. Bank accounts and other financial institutions can be designated as payable on death accounts. Now, the manner and the procedure to which you go about doing that depends on your financial institution. How it works is like this. This generally pertains to like your checking accounts, your savings accounts, your certificate of deposit accounts, your teller bank accounts. So your Wells Fargo, your PNCs, those banks. You can, and generally in my experience, it requires a face-to-face meeting. Is generally not something you can do over the phone. So you would more than likely have to walk in to make such a request. But again, contact your bank to find out what their procedures are. But ultimately, it's a one-time deal. You go to the bank and you appoint someone who also needs to be present as a payable on death party. Okay, they will not have financial authority or any access to your account until the time of death in that capacity. Okay, so this is helpful if you don't have a joint holder on your bank accounts in the time of your like if something were to take place and people needed to access funds quickly. This is very helpful and seamless. Again, once you put a payable on death account, or once you put a POD, appoint someone as a POD on your checking or your savings account, You only have to do that once. You can remove it at any time. You can change it at any time. But as long as you do it one time, it is there until you change it otherwise. Okay? And so it's definitely something that I think people generally overlook more times than not, that can come in so handy in unexpected emergencies, which I've been in more than I'd like to share. So this is why I stress um, these accounts, but specifically a payable and debt account is far too easy to put into place, for you not to consider that in a time of an emergency. If you own stocks, bonds, or mutual funds, you can assign, transfer, and death beneficiary designations also. Similar to a paid upon death designation, you would contact a financial institution directly and just appoint who your beneficiaries are. You will want to, again, contact your financial institution directly for their specific procedures in order to make that designation. But generally, it is a seamless, easy step. I've only seen in times with teller banks where you actually have to come into the bank. I'm not certain that would be, I don't believe that's going to be necessary here, right? Because it's a stock, right? Stock or bond. So I personally haven't seen a Fidelity on the road. And so I don't think you'll need to go there, right? No. You do it online. You can do that right online. Now that I say that, because that's how I did mine. Like, you can appoint your beneficiaries right online. You can change it every other day if you wanted to, honestly, but you don't want to do that because you don't want to lose track of what you're doing. But the point that I'm making is, for your stocks, for your bonds, for your mutual funds, this is accessible at your fingertips online to designate your beneficiaries. You don't even have to call them directly to do it for these forms of accounts. It's easy. So you shouldn't even miss this one. As a matter of fact, I'm going to go to the next slide because you're not going to miss it, right? Retirement accounts such as IRAs and 401ks and life insurance policies allow you to designate beneficiaries. Out of all of the non-probate assets designations that we discussed today, I believe that this one might be the one that folks are most familiar with: retirement plans and life insurance. But there are 2 points that I want to raise here. Okay. Similar to your securities, your stocks, and your bonds, you can appoint your beneficiaries quite easily with your retirement accounts by a simple phone call to your financial institution or doing it online, right? But additionally, if your potential beneficiary is a minor, consider potential guardians that can sign for them in your absence. With these forms of accounts, we tend to list our next of kin. We tend to list our spouses, our children, the ones nearest and dearest to us, right? Generally, a lot of times our beneficiaries are minors in these cases. In the event that you don't have an adult in place to assure that that minor is going to be taken care of, this is the time to consider that. Okay, even when appointing a minor as a beneficiary, in the event that something were to happen to you, it's not just a matter of guardianship to look over them. They need guardianship for someone to sign for financial resources for them. There's no financial institution or business that's going to sign over money to a minor. No matter the circumstance, there will need to be an adult in place. Establishing joint ownership with the right of survivorship is a straightforward way to avoid probate. Generally, jointly owned real estate can be set up to transfer automatically to the surviving owner. There's 2 major ways we're going to talk about today: community property with the right of survivorship and joint tenancy with the right of survivorship. Okay, so ultimately the distinction here is whether the couple is married versus unmarried. So generally, community property with the right of survivorship applies to married couples. It is presumed that married couples own property with the right of survivorship. So in that case, in most cases, and not when a married couple, when one passes and they owned real estate jointly, it's presumed they owned it with the right of survivorship, and that it will automatically, the interest of the spouse that passes automatically transfers to the surviving spouse, who will then own that property wholly by themselves without having to go through any court to validate that, right? That just happens by way of law, by I'm going to say the tool of the law. It's by the law, vehicle of the law, because it's the deed. The deed is what it transfers by, right? So you won't need a court to validate that deed unless there is a challenge brought by someone who says that the deed was invalid for another reason, okay? But you can also own property with the right of survivorship as a joint tenant, but the language has to clearly state that the property is owned as a joint tenancy with the right of survivorship. And again, at the time of death, the party who passes interest will automatically transfer to the surviving parties if the deed has the language to form a tenancy by a joint tenancy with the right of survivorship. Okay? Now, we touched on this earlier. I'm going to touch on it once again. You want to know that a transfer on death deed is a specialized deed that transfers your home automatically upon death, similar to life insurance policy, right? So, comparing to this, for instance, okay, joint ownership with the right of survivorship, with like a community property or a joint tenancy for a current tenancy of someone who's living and owning it now, right? As opposed to a transfer on death deed. A transfer on death deed is not effective until the death of the party. Do you understand? So rather than drafting a will, you would draft a transfer on death deed. At the time of death, the deed would then be in effect, and then the party who has gotten a deed will take ownership of the property without having to go through the court by way of transfer on death deed. So that is another way, okay, that you can avoid probate, and another way that you can transfer real property without having to go through probate at the time of death. Key takeaways: review is critical. Non-probate transfers override a will. It is essential to review and update beneficiary designations after major life changes, such as a divorce, a birth, or death in the family. So many times people fail to remove an ex-spouse from their 401k, their retirement plan, their life insurance, thinking that a court decree or something operates in that area, and it doesn't. It does not. So when it comes to your non-probate assets of all kinds, you are charged with the duty of assuring that it is accurate. So it is critical that you review it on a regular basis. Non-probate assets are a cornerstone of modern estate planning. They offer advantages like privacy and cost savings because they bypass the time and the expense of the probate court. And lastly, non-probate assets can be used for charitable giving. Retirement plans like IRAs and 401ks are popular non-probate assets to give to charities, as it can reduce potential taxes for heirs. Now, that's for a larger estate where you're looking to alleviate some of your tax expense for something associated with something that transferred at death. Okay, because there are certain estate taxes on a federal level that aren't even implicated until you're over $1 million threshold. I believe it was recently increased to $15 million or $11 million. In any case, I'm nowhere near there. And the vast majority of the population is nowhere near there. But fun fact, non-probate assets can be used for charitable giving. For every topic, I offer a resource or service or both. So today, I'm offering a quick reference list of non-probate assets that I drafted up as a quick reference for your home and for your non-probate assets. The thing about it is this: non-probate assets are vast and they vary. They're hard to keep track of in light of all the details of life. Anything that helps to make my life easier, I'm here for it. I believe in working smarter and not harder, and the resources and the services that I offer are in alignment with that vein. So here I drafted a list where you can add all of your non-probate assets by name and account in one document. It's 4 pages long. It has 7 sections for the 7 common areas of non-probate assets with an explanation of each area. It's free, it's downloadable, it's available 24/7. All you need to do is go to the website, create an account, be a member, and you'll have exclusive access 24/7. It's free. www.willfamlaw.com. Click create an account and join today. If you made it to the end, thank you so much. I look forward to the next video. Please like, share, and comment, and have a great rest of your day.